This is about Amy Cole Barrett that wrote this next piece. This is going to be part 2. This will for We the People News. This video is without prejudice and without recourse. Alright? I'm not waiving none of my rights, people. Alright? I'm not an attorney, so any opinions I throw out here is just my opinions. Alright? I'm not an attorney, nor care to be one. So just stick this to heart. Never, never, never. Never, never, never. Look just straight forward. Always look around you. Why? There's so much stuff going on around you. Alright? Pay attention to everything that's going around you, y'all. We're losing rights left and right. And how are we losing rights? I'm a firm believer everybody in that Supreme Court needs to be impeached to show that the next judges that come in better straighten up. But Congress will not let it happen because they're a bunch of darn idiots.
Court avoids another, let me try to put on my Amy Coney Barrett voice. The court avoids another ongoing scholarly debate on whether courts should primarily rely on the prevailing understanding of an individual right when the 14th Amendment was ratified in 1868, or when the Bill of Rights was ratified in 1791. This is a question? This is a scholarly question? This is a scholarly question that we need the Supreme Court to answer? That which is...
Nope. It's a traitor.
...more relevant? What somebody wrote in 1868? Or what the people who wrote the text in 1791 meant? I mean, seriously, how is this a scholarly debate? Can I tell you, I'm now wondering if Amy Coney Barrett has ever handled a contract law case? Or any of these scholars who engage in these scholarly debates have ever understood or had a contract law class? Because you see, contract law says you don't go for the meaning of the contract from people who lived 70 years after the contract was written. If you need to understand the meaning of a contract, you have to go to the people who wrote the contract in 1791. I mean, seriously, how is this even a question? How is this a scholarly debate? This is common sense, people, but remember, the only way the government can regulate your rights is through proper interpretation. And the only way you can get proper interpretation is to create new meanings beyond what the founders themselves meant. I have a series of pictures for you. I have to give Christian a little bit of time to pull.
You guys heard me on other videos about trickery of words. I mean, they got everybody running around with their head cut off because of trickery of words. How do you lose your rights, y'all? By giving consent or volunteering to get rid of them. You run down to your place and you ask to get a permission slip to bear arms. You gave up your right. You consented. You volunteered. This is not complicated.
Them up because they're not always in the most proper order when they come up. But I want to show you a series of quotes from the people who wrote the Second Amendment. Not something that I got from a seance, mind you, but something I got from them because they wrote it contemporaneous to the writing of the Second Amendment, to the ratifying of the Second Amendment. So, this...
By the way, before you hear this, this may be sensitive. If you want to live in illusion, do not listen to any more of this video. But if you want facts, then let's go ahead and proceed forward.
Court goes through an analysis of the Second Amendment. The right of the people, a well-regulated militia being necessary for the security of the free state, the right of the people to keep and bear arms shall not be infringed. Like I told you, 135 pages. We're not going through the whole thing. They go through a great effort to show that the people who filed this case, this is actually their words, the people who filed this case are definitely the kind of people, just general everyday guys, that were anticipated in the right of the people to keep and bear arms. They also...
Yeah, where's the commas, y'all? My last videos, I gave the commas. There's 4 different meanings in this. Alright? Nobody's talking about the commas. I believe she has in the past. I may be wrong.
They'll go into great detail to show that the militia is not one that's just government service. It's individual rights, that this is an individual right. But they miss the whole point of it because they go outside the history of it. Okay? Let me show you something. Sorry, Christian, to put you on hold, but let me show you something from the original opinion, page 12 of the original opinion. Do I have page 11 here? Start here. So, in assessing the post-ratification history, we looked to 4 different types of sources. I want you to notice, in assessing post-ratification history, why wouldn't they assess ratification history? There is a very detailed written history of the entire ratification process. Why would they only rely on post-ratification? Because all the...
Trickery of words, y'all. They're misleading we the people. Trickery of words.
Clarity comes from the ratification history, and that's what I'm going to give you, right? So 4 different types of sources, Thomas says. First, we reviewed 3 important founding era scholars who interpreted the Second Amendment in published writings. Wouldn't you like to know who their scholars were? Because I'm going to show you 3 scholars as well. Not the same scholars that they're going to show you. But I'm going to show you 3 scholars who wrote about the Second Amendment, who actually wrote the Second Amendment. Their scholars are St. George Tucker. Now, St. George Tucker is the only legitimate scholar on their list. St. George Tucker was an attorney and was an advisor to those who were writing and drafting the Constitution and the Bill of Rights. He wrote a very important treatise on how the Constitution and the Bill of Rights are to be applied in the legal world. He's a very important scholar. Quite unfortunately, when they refer to St. George Tucker, they misquote him, misapply him, and completely take his comments out of context to match what they want to hear, right? So.
She's being nice. Trickery of words.
St. George Tucker, they're only legitimate of the 3. The second, are you ready? An attorney named William Rowell in 1825. Right? 1825. We're talking 34 years after ratification. But remember, we're only concerned about post-ratification history. And then, Joseph Story. Those of you who have been watching us for a very long time, you have to know Joseph Story was going to be on their list because Joseph Story is the ultimate constitutional revisionist. Joseph Story is the father of federal supremacy and the father of judicial supremacy. He's a Supreme Court justice who rewrites constitutional interpretation to make the federal government and the judiciary supreme. So that was their historians.
Now, I had to say, and she disagrees with me, in 1871, they kind of changed it a little bit. Constitution for the United States and turned it into Constitution of the United States. Just saying.
So let me go ahead and read to you the three historians that our Supreme Court should have been referring to when trying to understand the proper application of the Second Amendment. We don't need an interpretation of the Second Amendment. It's not written in Mandarin Chinese. We need an application, and these three gentlemen, just three, there are many more who wrote contemporaneous to this, these three gentlemen will teach us what this is all about. The first is George Mason. Give me a thumbs up, Christian, when George Mason is up there, please. George Mason. It's titled, Who Are the Militia? Right? A well-regulated militia being necessary for the security of the free state. Who are the militia? George Mason says, when the resolution of enslaving America was formed in Great Britain, the British Parliament was advised by an artful man who was governor of Pennsylvania to disarm the people, that it was the best and most effectual way to enslave them. But that they should not do it openly, but weaken them and let them sink gradually. See, the governor of Pennsylvania was advising the British Parliament in the mid-1740s, hey, guess what? If you want to get these American colonists under control, what you got to do is disarm them. But don't show up door to door to disarm them and collect their guns, because they'll shoot you in the face. What you need to do is disarm them over time, weaken them gradually so they don't even know it, maybe through regulations. That's the best way to enslave them. This is what our founders knew, that disarming the people, government disarming the people, was a mechanism to enslave them. That's what they knew. Here's what he says. I ask, he continues, who are the militia? They consist now of the whole people, except a few public officers. But I cannot say who will be the militia of the future day if that paper on the table gets no alteration. The militia of the future day may not consist of all classes, high and low, and rich and poor. All right, bring me back, Christian. Listen, guys. You've got to listen to the words of the people who wrote the Second Amendment to know why they wrote it. That it is a straitjacket for regulation, contrary to what Justice Kavanaugh, contrary to what this majority court, what the whole court believes. It is a 9-0 opinion that your right to keep and bear arms is not a right, it's a permission from the government. Those who wrote it said the exact opposite. It's not about, and then they go into talk about how you can be limited because you can't carry scary guns. Right? No, they literally talk about the fact that you cannot carry guns that are scary, that regulations on things that are unusual and frightening are okay. That you can't carry what's usually carried, like large arms or whatever, right? So now we're going to hear from Noah Webster. Okay? Let me know when you got that one up, Christian. Noah Webster. Noah Webster, in 1788, helped write the Second Amendment. He says, before a standing army can rule, the people must be disarmed as they are in almost every kingdom in Europe. The supreme power in America cannot enforce unjust laws by the sword. Why? Because the whole body of the people are armed. Not only are the whole body of the people armed, but, he says, they constitute a force superior to any band of regular troops that can be raised on any pretense in the United States. So this whole myth about how the government should be authorized and is justified in regulating what kind of scary guns, what kind of big guns we can carry is completely abolished and destroyed by a man who actually ratified the Second Amendment, who helped write and ratify the Second Amendment. It's like, no, everybody's supposed to be armed, and we're supposed to out-arm the government. what he says. All right, put that one back up there, Christian. We're going to continue reading it. He says, a force at the command of Congress can execute no laws, like the IRS SWAT team or the ATF SWAT team. Those are forces at the command of Congress, right? No force at the command of Congress can execute, he says, a force at the command of Congress can execute no laws, but such as the people perceive to be just and constitutional. For the people will possess the power, and the jealousy of the people will instantly inspire the inclination to resist the execution of a law which appears to them unjust and oppressive. Oh, wait. Hey, Christian, no, Webster didn't mention anything about robbers and rapists, did he? He's talking about controlling the government because we outarmed them, controlling them from slavery, controlling them from ruling us with a standing army, controlling them from making laws that remove our rights. Well, the last one we're going to hear from is Richard Henry Lee, who is writing the letters from the Federal Farmer to the Republic. Okay? And this is just a segment, and this has to do with well-regulated. All right, what does the well-regulated militia mean? And he tells us, whereas to preserve liberty, it is essential that the whole body of the people, always possess arms. Are you catching a trend here? Not the part of the population the government gives permission to. The whole population. The ones who live respectfully, law-abiding, and don't take someone's life outside self-defense, destroy someone else's property, right? The whole body of the people must always possess arms. If something is essential, can you do without it? No. If you're always doing something, is there ever a moment when you're not doing it? Because you see, if you have to have a permission slip, and the government can say, you can here, but not here, then how can you always? He said, essential to the preservation of liberty, that the whole body of the people always possess arms. So if you want to preserve liberty, then the whole body of the people must have the opportunity to always possess arms. But on the contrary, if your goal is to destroy liberty, then you want to ensure only a part of the approved population can carry arms, only where the government wants them to carry. See how that works? So we have to understand that the intent is found in the history, but history is not always indicative of intent. So what we have is a Supreme Court that goes through great lengths to talk about much history without actually going into the history that's actually relevant to the intent and application of the Constitution. Now, kudos to Clarence Thomas for pointing out quite boldly that it is in American history the deprivation of the right to bear arms most importantly enforced on minorities to keep them minorities and keep them out of power, right? He says, let's see. Even before the Civil War commenced in 1861, this court indirectly affirmed the importance of the right to keep and bear arms in public. Writing for the court of Dred Scott, Chief Justice Taney offered what he thought was a parade of horribles that would result from recognizing that free blacks were citizens of the United States. If blacks were citizens, Taney fretted, they would be entitled to privileges and immunities of citizens, including the right to keep and carry arms whenever they want. See, he even midst of denying segments of the population the right to keep and bear arms. Why did they want to deny the black Americans their right to keep and bear arms? So they could keep them oppressed, so they could keep them under subjection, right? Why do they want to limit your right to keep and bear arms now? So you can be oppressed and under subjection. But even in those days, when they were trying to impose that on the minority of the population, they recognized that citizens were entitled to the right to keep and bear arms wherever they wanted. Wherever they wanted. And so what we have was this 5 pages of Clarence Thomas explaining to us why government regulating our right to keep and bear arms is dangerous, while at the same time saying it's okay for the government to regulate our arms if they give us a good reason. A little bit of double-mindedness there. I'm not sure where, they're missing the point, but that's the bottom line. Now, Justice Breyer. You got that Supreme Court picture up there, Christian? Throw up the picture of the justices. Justice Breyer, who is, sort of grayed out in this picture because he's not sitting anymore, writes the dissenting opinion. And he writes a 50-plus page dissenting opinion that is utterly and completely stunning. The very first sentence, in 2020, 45,222 Americans were killed by firearms. See the Center for Disease Control. Since the start of this year, there have been 277 reports of mass shootings, an average of more than 1 per day. He spends, I don't even know how many pages giving statistics and telling us why it's necessary for the government to regulate our right to keep and bear arms. I want to show.
That being said, now I haven't heard all this all the way through, but I pretty much trust her. That being said, where is statistics saying how many times and how many people was saved since the beginning of this year? Nobody, absolutely nobody, talks about that. Just saying.
If we're talking about history, I want to show you what William Pitt the Younger wrote in 1783. Christian has a really nice slide for you, and I'm going to read it to you for those who are just listening. Was it not necessity, which had always been the plea of every illegal exertion of power or exercise of oppression? Let me go ahead and repeat that for you, because this is a very important phrase that we must understand. Did you find it, Christian? This is the one you wrote. Okay. Was it not necessary, was it not necessity, which had always been the plea of every illegal exertion of power or exercise of oppression? Was not necessity the pretense of every usurpation? Necessity was the plea for every infringement of human freedom. It was the argument of tyrants, and it was the creed of slaves. The entire dissenting opinion falls into that category of an argument for tyrants or a creed for slaves. And it's almost humorous because, they wanted to play off the majority court's reliance upon history. And he puts in history, he says, the question before us concerns the extent Okay, the question before us concerns the extent which the Second Amendment prevents democratically elected officials from enacting laws to address the serious problem of gun violence. Well, I'm pretty sure the answer to the question is shall not be infringed. But remember, the court has a problem with that today. But I want to wrap up this session with the hysterical references that Breyer gives to justify government regulations. Okay? He says, the English Bill of Rights do not protect an individual's right to possess, own, or use arms for private purposes, such as defend a home against burglars. The English Bill of Rights didn't do that. The English Bill of Rights, written in 1789. The English Bill of Rights, signed by a king. We're supposed to think that's relevant history, that a king didn't want their people to have the right to possess arms, to own or use arms for private purposes, such as to defend the home against kings. Now, this is our standard. Oh, it doesn't stop there. No, it doesn't stop. Let's see. We have this whole section beginning in section 4. The court's application of its history-only test in the case demonstrates its very pitfalls described. Historical evidence reveals a 700 Anglo-American tradition of regulating public carriage of firearms in general and concealed or concealable firearms in particular. 700 years Anglo-American? How about kings denying you your rights? Kings are the standards. Law regulating public carriage of weapons in the 13th century? Kings? Similar laws remained on the books through the ratification of the 2nd and 14th Amendments through the present day. Yeah. Through the ratification of the 14th Amendment, and because we wanted to keep minorities.
Remember, y'all, she's not going to bring this up. We got Roman civil law. So, of course, they go all the way back there because they brought Roman civil law into our courts today. Supreme Court knows this. So what are they doing? Are they bringing in foreign laws and going by it like they did with the Roman civil law that we are operating under today? Think about it.
From keeping guns. And by the way, similar regulations were not in place during the ratification of the Second Amendment. That is a complete and utter falsehood, a misapplication of that history. And I will close with this because
I have to say, she keeps on saying misapplication. It is on purpose. It's trickery of words designed to take you down.
Never in my life have I heard a Supreme Court justice actually say that Supreme Court judges are not smart enough to do something. And I have right here page 26 of Breyer's dissent in writing telling us that judges are not smart enough to know history. They're not smart enough to read what the founders wrote. He says, judges are far less accustomed to resolving difficult historical questions. Legal experts typically have little experience answering contested historical questions or applying those answers to resolve contemporary problems. Difficult? What, they can't read? You can't read what I just read to you from Noah Webster and from George Mason and from Richard Henry Lee? You can't go read the ratification debates because it doesn't take rocket science.
If you're supposed to be a constitutional Supreme Court, don't you think that'd be obligated for you to at least minimum research it? instead of sitting on your buttocks? I don't know, people.
Level understanding of history to be able to read these things and understand them. They wrote in basic, simple English. I don't think, Christian, when I read those quotes, and you were, you saw them long before everybody else did. Were there any words in there you didn't understand? I mean, this is 6th grade English, people. And for Justice Breyer to tell us it's too difficult for him to understand what they wrote, maybe we should understand that he wasn't qualified for his job? Maybe because they're not taught to go there, right? The court's insistence that judges and...
Okay, so let's go with taught to be there, right? Then that means they're not qualified. Now, for some of you guys don't know this, Supreme Court judges don't even have to graduate from high school to be actually put in office. It's just the government wants bar members in there because they cannot have any of we the people that actually understands the Constitution up in there because the government would collapse. Just saying.
Lawyers rely nearly exclusively on history to interpret the Second Amendment, thus raises a host of troubling questions. Oh, and it doesn't raise a host of troubling questions that courts and judges and lawyers must rely nearly exclusively on think tank writers and law journalists and pundits and scholars who absolutely were not there when it was written? That courts and judges and lawyers are to rely nearly exclusively on history post-1850 to interpret their Constitution? To rely nearly exclusively on history and writings of...
Who is brave enough to actually write out a claim from harm being done of denial of natural right to protect themselves? Sit and think about it, y'all. Because that's what they did. They actually harmed you by not letting you be able to protect you by any means necessary, and absolutely confiscated your rights.
People that know nothing about actually the written document itself.